Commissioner Isbell?
Here.
Commissioner White? Commissioner Grant? Here. Untitled.
Present.
5 here and 3 absent.
At this time, would you please stand for prayer led by Commissioner Fritz, pledged by Commissioner Meade.
Our Father, we just thank you, Lord, for this day and the many blessings you've given us. And Lord, we just ask that you continue to bless this country, Lord, and the many people who are still suffering from this pandemic, Father. Reach out and touch the ones who are still suffering and bless the families that are dealing with it, Lord. And Father, just be with this committee tonight, Lord, as we conduct the business of this county. Help us, Father, to open our eyes and our hearts, Father, as we conduct this business, that we do what is best for this county and we want to do your will. Forgive us when we fail you. For it's in Jesus' name I pray. Amen.
Amen.
Please join me in the pledge to our flag. Hand salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Chairman, we have Mr. Smeltzer, Gavin Smeltzer from Owens Coleman here tonight. He's going to help us with any legal questions that you may have. Gavin's been putting in a lot of time on this, and he's here to help us review these final chapters and make any edits that you see. And I know you've sent me some that you want to do, but anyway, Gavin's here tonight, and he'll do a good job for us.
Okay, thank you. At this time, I hope y'all have read the minutes of the previous meeting, but we need the approval of the January 3rd minutes.
Move for approval.
Motion's been made to approve the minutes. Do I hear a second?
Second.
Motion made and second. Any corrections or objections to the minutes? If not, all in favor of the motion, say aye.
Aye.
Those opposed, like sign. Motion carries. Appearance of citizens. We have anyone here tonight that would like to address the commission? Okay, seeing none. Mr. Yeager?
Sir, thank you. Again, I want to remind you, there's two options on presentation of this charter to the citizens by referendum. That's to do it in the August election or do it in the midterm federal elections. That'll be November. So that's a very important decision you need to make. I think the deadline, Mr. Stevens told me, is May 22nd for the August, and I'll have to look at his schedule and see what he said. I think it's early August for the November federal election. So either one of them is a general election, and we can present it at either time. Okay, I don't know if you had a chance to review the drafts that have been sent out. We've got to go over these tonight. I'll try to be fast, but there's several decisions here that you're going to have to take a look at. But I'm going to start with one on education. That's Article 6. That's all right, Jerry. Annette was talking bad about you, but we straightened her out. Article 6 is about the Board of Education. Remains the same. With 8 members, that's what we've got now. We need to add that it is on a staggered term basis. We have half elected at one time, and then the next 2 years we changed that. You remember that, I think 02, we changed that, so we've got staggered terms there. Gavin, if you can write that in. Then here's in section C, this is a question that's come up and that we need to get ironed out is what are we going to call the Board of Commissioners? I saw in here there's a section there that talks about county commission. This body has talked about that they believe it's the legislative body because it's referred to in the statutes as the legislative body. The only other way I've seen it is the governing body. I don't want it to get confused with a school board or any other board that we may have. We have several entities that are actually boards other than committees. So we need to iron that out. But right now, I think we've got a motion that was passed that this body, the county commission, would be the legislative body. Is that correct? Is everybody in agreement on that?
Can I ask a question?
Yes, sir.
Is that county legislative body or just legislative?
I think once you put in there that first section, Anderson County, after
Okay.
that, we can just go legislative
Okay,
body. Just,
got it.
one of those here and after referred to kind of things.
Sure.
So then we can take out some of the stuff where we say Board of Commissioners and County Commissioners, but thank you very much. Now, on vacancies, it says vacancies occurring on the Board of Education shall be filled by the Board of Commissioners, which is the current state law. Board of Education members appointed by the Board of Commissioners to fill a vacancy under this section shall serve for the remaining term of the vacant seat. I think state law says the next general election on that. Do we want to deviate? Otherwise, you're putting an appointed person in an elected position for the remainder of that term. Somebody could come in 2 months later and resign for medical reasons or whatever, and that appointment that the county commission would last throughout that term. The way we've done it before is that appointment from the county commission only lasts till the next general election, and then they will let the voters decide at that point. So is that okay with everybody to stay with general law on that?
I move to stay with general law.
Okay, thank you very much.
Yeah, Jay,
Yes, sir.
yeah, in regard to the Board of Education, I noticed that there's also a state law that calls for recall by the voters.
Yes, Gavin's got that in here.
Say again?
Gavin's got a recall section in here.
Okay, and I also noticed that there's a change to it right now. I think I sent you a copy.
You sure did. Thank you very
And
much.
they're changing
Those
it from a
updates.
66% in favor of recall to only
He actually
greater
left
than
blank-
50%.
He left blanks in there, so.
And of course, that's not passed yet, but I
Right.
expect that it will.
We're following that. And he's got the conflict of interest statute towards the back of these articles tonight, and we know that's changed. It looks like it's changing again. So we'll try to keep on top of that. Yes, sir.
Well, and this is just for my clarification, I guess. When state law changes, this charter changes if it's approved.
That's sort of debatable.
Yeah,
Gavin, the way, you're creating a new government with a charter, okay? It cannot be in conflict when you pass this charter. It cannot be in conflict with state law. But what's your thoughts if state law changes?
well, I would say that state law changes in terms of public acts, they would affect the county government. In terms of private acts and any private acts passed by the General Assembly, I don't think those would, of course, not have any application. But I think
State law changes?
correct, yes.
Okay.
Because
Does that answer your question?
Yes.
Okay.
Tell me what he said.
Basically, what VL said is if we pass this charter and the state law changes on an issue we have embedded in the charter and passed by the citizens, what controls? And Gavin's belief is if a general law is amended at the state level, then we're going to be under that. The charter cannot be in conflict with state law.
or the Tennessee Constitution, for example.
right.
Correct.
You got it?
So the state law would trump,
Yes, sir.
okay. Yeah.
Okay.
Yeah, that's really what I was asking on that. And then another one along that line, and I've been out 13 years, and I had a question about the local tenure law.
He's got that in there. Can I address that when we get to it?
Yes,
I'm in section E on Article 6, first page there. The districts of the members of the Board of Education as created by this charter shall be identical in geographic composition to the Anderson County district boundary lines as those boundary lines exist on December 31st, 2021. Now, we know we have reapportionment every 10 years. That's mandated. The board may, if you see that highlighted section, it's hard with the black and white. It says the board may from time to time alter the boundaries of districts so long as all districts comply with the constitutional requirements on or before, and that's talking about the every 10 years. My issue with that is I don't think the way we've got it set up that the Board of Education, they have that ability, but the way we've got it set up, they follow county commission districts, and that's very important. I would hate to see the Board of Education go to different districts, and that would be very confusing. The way it is now, we know that there's 8 Board of Education districts, and they actually mirror the 8 county commission districts. Now, every 10 years, of course, we have to reapportion that by state law. So, and we want the Board of Education to make any changes. It's much easier for the Election Commission. It's much easier for our citizens to follow. So that's my issue on that. Anybody got any comments on that?
Yes, I think that when we said no changes.
Right. That's what we meant.
I thought that spoke to it, but that's up to whatever y'all.
Well, I was saying that, you know, I've been through the redistricting a couple of times now, and we always take into account how it's gonna affect the school board people, the school districts, and is it gonna move, you know, like all the schools out of one person's district or something? We take that all into account. And we don't do it in a vacuum. I mean, I think the school board members, you know, are involved enough to know how is this going to change the district and stuff. So I think it just, even though there's this is written this way, I really think it says it should mirror the changes that are made for
Right.
the legislative body, or
Mr.
the
Chairman.
words that effect.
Well, we did that in our operations. I was chairman of the redistricting, and you cannot take a school board member out of their district. It has to stay the same. In other words, yeah, you can't split the district to move anybody. If whoever's seated in there has to stay the same.
Okay, though, Gavin, just to give you some clarity.
Sure.
We want those school board districts to exactly mirror the county commission districts, the same as it is right now.
Sure.
And
I will say that I think we tried to get that in the first sentence, but it stays the
You
same. In the second sentence, generally, we've tried to be permissive to give you all the option to change, or, you know, grant more powers or whatever, to change that. But if you don't want that, then we can strike it.
okay, everybody okay with just that simple statement that the school
Yeah.
board will basically be the same districts as county commission? Thank you.
know, and I'm for that. I like
Yes,
what
sir.
you're saying, because, and Jerry White, of course, he was gonna run for commission anyway, but
He was the odd man out
we
on the
had-
school board.
well, we had 2 in.
But we were blessed to get him on county commission.
Same district, didn't we, Jerry?
Uh-huh,
And he said he was gonna run for commission, so it stayed
absolutely.
in effect.
That was a good move for us all, certainly the citizens out there in 5.
I think it still needs to address that, you know, in accordance with state law, we have to redistrict every.
He's got that, but can
So
you
we
take
can't
care of
leave all
that,
that off.
just that reapportionment?
Sure.
Every 10 years. Okay, I'm down on F, page 1. No person shall be eligible to serve as a member of the Board of Education unless that person shall obtain the age of 18, that's statutory, is a resident of and registered voter of the district from which such person seeks election on the date he or she filed his or her nominating petition and has been a resident of both the county and district for 1 year prior to such person's election. Provided, however, and here's a couple of issues, that the district residency requirement shall not apply in the first general election after redistricting for the general election at which a seat on the Board of Education appears on the ballot. A member of the Board of Education shall remain a resident of the Board of Education district which such member represents during his or her term of office. No member of the board or any other public official or employee of the Board of Education shall be eligible for appointment or election to the Board of Education. So that's number one. That last sentence, I think, is what we're trying to say is no member of the county commission can be a member of the Board of
Correct.
Education. So we'll straighten that out by inserting legislative body at that first board. Then that starting where it says however, that the district, I think that's what Tim's talking about in Tennessee law there. But we do want it to apply in the first general election, though. We just want them, the issue is removing a sitting Board of Education member from their district just because the district boundaries change. Okay, I can see that where the staggered terms come into play. That could be a possible issue, but more than likely or not, as far as county commission is concerned, that wouldn't apply because you know what district you're running in to begin with. But now that we've got staggered terms on the Board of Education, you could have a member that is removed from their district because they no longer, once the reapportionment, redistricting occurs, they're removed from their district. So we might, you understand what, we might need to clean that up
Sure.
just a touch. And I think that should only apply to the ones that are in that 2-year remainder of the term, not anyone that's in their a full 4-year term after this is passed. Then you're going to have a problem with somebody representing people that they don't live in that district, and that's a big problem. Okay, to page 2, Article 6. Here we go to that one thing that I've got some changes with. Anytime we refer to the chairman, they've got in parentheses woman. I've sent this back, I think, to John, but where it says chairman or chairwoman, the Charter Commission has voted to leave that just as chair. Refer to that position as chair, not chairman or chairwoman. We'll refer to that position as chair.
Sure.
Okay, that shows up in several different articles. Okay, subsection C, there we've got chairwoman. Again, just change that to chair. Subsection D, are you going with, it talks about ordinance, are you going to go with the statutory definition of ordinance that's embodied in TCA?
Yeah, I think there's, it sets out a statutory scheme for ordinances in the Charter Commission statute, yes.
Okay. And you attempted to define it in the back. I believe I saw that in the terms.
I believe so.
Okay.
I would have to look.
That's going to be a little bit different, and the interplay there is with the term resolution. We pass a lot of resolutions. In fact, there's some old case law that says county commission speaks through resolutions for the county. And if you ever seen some of our old minutes that go back 20 years, all it says on there for each motion is it says, be it resolved, be it further resolved, be it further resolved. And it goes on down to say, okay, county commission is speaking through a resolution. We don't do that now. We list the motions and who voted for what, and that's it. So the difference between a resolution and an ordinance and a proclamation needs to be clearly spelled out. We have been operating under the assumption that an ordinance has some kind of punitive repercussion to it. But here, if you look at we'll get to this later, the term resolution is not as broad as ordinance. So I want to stay in line with TCA. I don't want to venture far from it, but that's going to be a little bit different. We need to make sure, Gavin, that we know the mayor will do proclamations to honor people from time to time. The county commission passes predominantly all resolutions, unless it's sent up from the mayor as a proclamation. But even when we honor people, citizens or officials that are retiring or whatever, we do resolutions. But anyway, that's the issue there. Okay, the director of schools shall be the secretary of the Board of Education and executive officer of the board. That's not how we have it right now. I think the director appoints the secretary. I know it's Pam Crawford. VL, do you remember how that was? The director was not the secretary.
And,
Did you appoint the secretary?
well, the only person, I think this is by state law, once they went to appointed superintendents, the only person that, the board hires is the director of
Director.
schools. The director of schools hires everybody else.
Okay. Do you have authority on that you want to talk about, Gavin?
Well, I've discussed it here. I kind of have some notes on my own.
Okay.
I've actually researched that exact question. My notes here state that Tennessee law doesn't speak to the issue, so there's no requirement that the director be the secretary and vice versa. So it's basically up to you all, how you want that. If how the way it is right now, if that's how you want to keep it, then we can draft it in there like that.
Well, the two options are, do you want the school board to appoint their secretary, or you want the director of schools to appoint the secretary to the board?
And I will say that the private act that I was reading in researching that didn't speak to it either, so it's totally up to you all.
I think that's a new provision. Any thoughts on that?
I would defer that to, since the VL used to be a director of schools, how you feel about it.
Well, first of all, I didn't have to do that because Pam was there and stayed.
Uh-huh.
Who appointed Pam to that position? Was it the school board or you?
Well, I'm gonna tell you what the board told me on the night that I was appointed officially, that, and I said, this is where everything changes. Dr. Burrow said, we're the policy-making board, all personnel is yours.
Okay. Are you saying you would prefer to have the director of schools appoint that secretary to the board? Or the board itself appoint their secretary?
Well, let me tell you this.
It's very hard for a board
Well,
member to be a
yes.
secretary on something.
The board appoints the director of schools.
Right.
The director of schools is not going to appoint somebody as secretary that the board doesn't want.
Well, let's just leave it as the board appoints the
Yes.
secretary. Is that,
right, Jerry?
let's just leave it that the board appoints its own secretary, a non-member. I don't want to tie somebody down that's a member with secretarial duties.
I
That's,
think
we
we
can
just said
pull it
the
off.
director will appoint the secretary.
I thought, I heard you say that you kind of felt like the board should appoint that secretary.
Well, I don't think the director, since he's appointed by the board,
Right.
is going to appoint somebody that's in conflict with the board.
Yeah, I understand that. So I think the reasonable way to resolve that is to allow the board to appoint their own secretary.
If
Not
it's-
from their membership, that's gonna be too much.
If it's not in conflict with the law, I don't have any problem with that.
Anybody else want to talk on that issue?
But the director of schools, like you just stated a minute ago, is appointed by the board or hired by the board, however you look at it. And then the director is responsible for all the personnel in that organization and responsible to the board. And so that's just one of the personnel, I think, that's pretty important, the secretary of the board, because
So
that's
you're leaning to the director
the
appointing.
director appointing it, and the director's not gonna appoint somebody that the board doesn't approve of. And that's not gonna happen, because the board can remove
Well,
the director,
They can reject the appointment.
yeah, or could eject it. Should it be that it's, nominated by the director and approved by the board? Or that would be kind of an in-between.
Well, I was just basing my opinion on what I thought the the law changed specifically when it went statewide with appointed directors of schools.
Okay,
And that's what I was told.
all right.
Just a quick thought.
Yes, sir.
When I was on the Board of Education, we hired a director of schools from Alabama, J.V. Saylor.
Mm-hmm.
We had and I don't remember her last name, but I think the secretary's name was Betty something.
Mm-hmm.
And she'd been there a long time. I don't know how long. Was her name Betty? Did you?
Yes, Betty Wise.
Betty Wise.
Mhm.
Betty, I forgot that name. But Dr. Saylor's had a little uneasiness about Betty. But she'd been the secretary a long time, and the Board of Education, we encouraged him to keep her until she retired.
Okay.
And as soon as Betty retired, J.V. Saylor's hired a little lady out of Oliver Springs named Judy something. And she remained there until J.V. went to Nashville.
Okay.
But it was J.V.'s call.
Okay, how about this? The director of schools appoints and the Board of Education ratifies that appointment. That's similar to the statute that the county mayor has on committees. County mayor will select and then the county commission ratifies that appointment.
I'll make that as a motion.
Second.
Motion made and second. We'll have to call the roll. Any other discussion on
That's sort of the way a man is now. We make a decision and the wife approves it. And
That's the kind of terms we can all understand, Jared.
that? I just don't want us to be in conflict with state law. But any other discussion? All right. Please.
Commissioner Meade,
Yes.
Commissioner Fritz,
Aye.
Commissioner Isbell,
Aye.
Commissioner White, Commissioner Bochamp, Chairman Stonesifer.
We gotta have 5 to pass that, don't we?
Mhm. I tell you what, if you want to,
We got 6 here.
the one thing I'm going to ask Gavin to do is make sure it's not in conflict with state law.
We got 6 here.
Mhm.
I'm gonna vote no.
Okay. You want to declare the vote then?
Motion carries.
Okay, Gavin, if you would, make sure that's not in conflict with state law. And what he's talking about is the statute that allows the director of schools the authority and supervision over all personnel. And that's the question we have on that. Thank y'all. I'm moving on down. All members of the board shall give a bond. We do that now. The next one I have a question about is 6.03, Board of Education salary and compensation. Each member of the Board of Education shall receive compensation in the amount fixed by general law. VL, is that the way they do it now? Do they use the state statute formula?
School board, can set their salaries, but they can't, it's just like county commission. No, it's not like county commission, because they have staggered terms. The school board sets their salary.
Okay.
That's right, isn't it, Jerry?
Can you check that one? To
Sure.
see if there's a
I thought it
general
was- I
law.
thought it was the same as commission and just tracked with us.
Well, he's got a reference here to general law, so that's what
Yes.
you need to check and see what that general law is. I'm not sure.
Well, you got every 2 years, you have some board members elected.
Mm-hmm.
So some people get a raise.
You're talking about the statute that says you can't raise your salary during your term of office. Okay, that's written. I know where that's written at is in judges' salaries. I think county commission has followed that rule to some degree, but I don't think it's actually embedded in the statutes in Title V. It is for judges. You can't change that salary of a judge during their term of office. Okay, you got that, Gavin?
Yeah, I will add one comment.
Okay.
Where I got that from is Section 14 of the Private Acts of 2002, Chapter 101, which is, I believe, the governing private act.
That's the
and-
last one on the
Correct.
Board of Education.
Section 14 of that private act says the duties, responsibilities, and compensation of the board members, talking about the Board of Education, shall be fixed by general law. So I figured that that was how it was being done currently. And so you have insisted multiple times that you want everything to stay the same, so I've done that.
Okay.
I will go check and,
We'll check 49 to
Okay.
see if there's just something that, that says the Board of Education can set their salaries.
Well, time out.
Yes, sir.
You mentioned the private act.
yes, sir.
That was the one where we went to 8 districts.
No, it goes back, there's another private act that I think, when they gave the option to all counties where the board appointed the superintendent, we had a private act prior to that.
It's a, what, 41?
No,
The one in between there?
no.
I don't have
it
my
was,
private act book.
80, 88,
I'm not aware of a, are you, 1988?
I believe so.
I'll check my private
I'll
act
have to
book.
check. I do have 1941.
Yeah, that's the one I was thinking of, but maybe VL knows it better than I do.
Sure.
Let me, some of you can remember this.
It might be a general law.
We had a private act before that, before the superintendent was appointed. And that was when Paul Bostic was
Right.
director of schools. And then we had a referendum that took place to have an elected superintendent.
Mm-hmm.
And then after that, I want to think we had another private act to where we had an appointed superintendent, and that's when J.V. Saylor was appointed.
That was interesting, wasn't
Yes. Is that, am I telling this right?
Well, that referendum failed.
No,
It passed?
it passed.
Who was the one elected under that?
Terry Weaver.
Okay. All right, let me go back, and I've got the Book of Private Acts for Anderson County, and I'll check that real close.
And then when Bredesen came along as governor, is when every county, and I said every county, cities already had their charters. And would be considered private acts, the cities that had school systems. But that's when all the counties had the board had to appoint the superintendent.
Okay. All right, I'll get to the bottom of that issue, and I'll report back to you. I've got a
Okay.
book of, I think,
Okay.
every private act that's ever been passed. Okay, I'm on page 3. Okay, it goes into elections, and it's pretty detailed here, and this is the big question. You voted before for nonpartisan elections. If we stay with nonpartisan elections, there's no need for a primary. If you want to have partisan elections, then we need to keep all this stuff about the primary and all that. So that's a big decision here.
We haven't voted on that, we just had interest in it, but I don't think we've ever voted.
I brought it to you a couple of times, and I'm not sure if we've had a motion on it or not.
We did.
You remember that? I know the first time we didn't have anything, it was just discussion.
You said there was a law, there was a way that it could be done.
Right, through the charter, you
Yeah,
can have
I was
nonpartisan.
interested in that, to see.
The charter, we've been told by the attorney, the senior attorney for for the State Election Commission that they'll honor a private act or they'll honor a charter or a general law local application that allows for nonpartisan elections. This would be a charter provision that had nonpartisan elections in it.
Well, did you put it in here?
Yeah, he's got it in Article 7. Well, what it talks about is primary elections, and if you're going to go nonpartisan, there's no need for primaries.
Should they say primary election when held, or is it, because this says required?
Well, they're thinking about a partisan election is what that's what you were thinking about when you wrote this.
Well, presently is I know commission is presently nonpartisan. Is school board presently nonpartisan?
I think they just changed the state.
That state law just
I know, I
changed
mean,
last session.
for this election coming up, is they're changing everything, which I do totally not agree with. But for this charter, which we can change back to the way we've operated for years and years and years and years, which I think is ideal for the county commission. And I'm just asking, in the days of old, how was the school board nonpartisan or partisan?
This year, they had a law passed.
To make it partisan this year.
So in the days of old, though, it's
What he's
nonpartisan.
asking about before, it was nonpartisan.
It's just like county commission here this time.
Then I move that we put these back as just like the county commission then.
Would you hold off on that motion?
Okay.
Well, let me tell you this, okay? You've got to also understand what positions it applies to. We've had partisan elections for our fee offices for years. Like I told you before, there's a couple counties that actually have the DA as nonpartisan. That's a state position, but they pulled it off through private acts or general laws of local application. Shelby County is one of those. But the way we've had it here in Anderson County has been that the constables, the county commission, and the school board has been nonpartisan. Well, we can't do anything with the school board, okay? That's been changed by the General Assembly, and I think they're trying to drop a bill where county commissions will be partisan. But if you make a motion for nonpartisan elections, you're gonna have to say all county offices or delineate exactly which county offices. If we're trying to stay the course of what we talked about before, keeping Anderson County pretty much the same way it's always been, then you would have nonpartisan elections for the county commission and the constables. Everybody else, I believe, has been partisan. Correct me if I'm wrong. I know we've always had primaries for trustee, register of deeds, county clerk, all those, highway, all that.
Well, that's what I was wanting to do, is keep it like we had it.
Okay.
Well, it's always been, everybody else stayed, the partisan races like that they wanted to do it, but, the county commission, the constables, and the school boards, who's always, for days of old, been nonpartisan, let them stay nonpartisan.
I thought if it was in the charter,
It can't be in conflict with state law. That's why we can't put something in here that brings back the Board of Education is nonpartisan. That's already controlled by state law.
we could do everything else,
Right, that's not controlled by state law.
including fee officers, sheriff, mayor.
That is not controlled by state law, other than the bonification process that's written in there that the parties decide. But as I told you before, the senior attorney for the board of or the state election commission has said they honor charters, private acts, and general laws of local application that state nonpartisan elections. There's a movement across the state to make county commission, all offices partisan. But I think if you're going, like Commissioner Fritz said, if you want to take it back to where it was before, you can only look at the offices that we could do this to, and that would be county commission and the constables. The rest of them, I think the parties have always decided, the Democrats and the Republican executive committees have always said they're going to have partisan elections for these other fee offices. So if you, again, what Chuck has recited is the way it's been, except for the school board.
Well, the reason I asked you to hold up on the motion is I wanted to include everybody. I wanted to do away with primaries in Anderson County.
I'd be agreeing on that too.
Well, that can occur, except you may have a situation where you'd have to have a primary for the school board. We can't control that. I don't know if that'll ever happen. We haven't had that many before, but again, this will be our first election for the school board being partisan, but you could make all Anderson County positions nonpartisan. There's no doubt about that. I don't know if that would be troubling to the public. It just depends on who you talk to. But I think that is an option right now, certainly yielding to the advice of the State Election Commission attorney.
Thank you, Mr. Chairman. I agree with the partisan. And all should be partisan, because I'll tell you why. We got a neighboring county that they all run as independents. And the county executive gets elected by 27% of the vote. And that's what you find when you have independent. The thing about partisan elections is it takes it down to what the public thinks are your two best candidates. And that's what I like about it.
Well, we've always had partisan election for the county executive.
Well, the same way with the county commission.
That's
I like that too.
we've had partisan elections there.
So there's a private act by commission right now in Nashville to try to change everything back the way it was to begin with, right?
They sent a private act down. It was passed 15-1 in October. We've not heard back, and that would make county commission and constables nonpartisan.
Yeah, the school board thing is already passed in
The-
the general laws.
Right.
And I'm just not, just me personally, everybody else can vote how they want to, but me personally, I'm not interested in nonpartisan elections. We've been sitting here for months, or the months that I've been here, saying we're not gonna make any changes. That's a huge change. And I think if we are gonna put that on the table, then we have to go back to the original reason that this charter started. The people signed a petition wanting term limits. So if we're gonna alter the complete way that we're doing our voting system, I think for the people, we have to go back and talk about term limits again, because that was how this whole thing originated. And I'm not for term limits. I think on your local level, your people will vote out the person that they don't want in office. But at the same time, if we're gonna sit here and make changes, we have to put that back on the table.
Good comments. I think what Commissioner Fritz mentioned was exactly what we've been doing in the past. That's no changes. Am I correct? Is that what you were talking about?
For commission and.
For commission and constables, but everybody else remains partisan. But
Well, me personally, I don't like taking that away from the Republican Party or the Democratic Party.
Gotcha.
They have that right to hold primaries. They have the right to hold caucuses. I don't feel like this governing body should tell them that they can or cannot do that.
very good comments. Thank you. Okay.
Well, I got one more thing to say.
Yes, sir.
I don't have anything against the Democrats or Republicans either. My point is that, and it opened my eyes, because the county commission and the school board have always been nonpartisan. And I served on county commission, and one time, there was an issue that came up that came from the National Party. I voted against it. That didn't bother me as much as it would today. But with so-called dark money being in politics now, I would hate to see the national party of either one, Democrat or Republican, or the state Democrat or Republican Party, pouring money into Anderson County for a local election because it's partisan.
Yeah, I think that was one of the reasons we heard county commission talk about, are they gonna have to subscribe to the national, political agenda for Republicans and Democrats? Is there somebody gonna be looking over their shoulder and say, you ran as a Democrat, this is not what the Democrats, on the national level want? And, but anyway, is there a motion on the floor, or are we ready to move
Are
on?
we ready to move on? No motion, don't think.
Okay,
Unless-
all right, then that means we
I
need
thought
to
there
go.
was a
Let-
motion.
let's- We
I
didn't,
thought Chuck made a motion.
Did you make a motion?
Chuck made a motion, we didn't have a second.
Okay,
We can bring things up again next
Certainly.
month, right?
yes, sir.
Okay.
Okay, well, let's take a look at these elections with the primaries in there, because that looks like the way we're probably gonna be going. I'm looking at 7.01, a primary election shall be held in Anderson County for the selection of all political party nominees of all parties, which are qualified under Tennessee law as political parties, for the selection of candidates for all county offices, judicial offices, and all other offices which are filled by the voters of Anderson County at the August general election in even number years. All such elections shall be held in the manner provided for holding such primary election by general law. Okay, we're going to 7.02, data primary. The primary election to nominate candidates for the county general election shall be held on the first Tuesday in May. I believe that's state law, isn't it?
I think so,
Okay.
yes.
Next preceding the county August general election, in years in which a presidential preference primary is to be held in the state of Tennessee, the county primary election shall be held on the date selected by the legislature for said presidential preference primary. So is that a problem? Because that presidential preference primary is at a different time
It goes
than May.
Goes by Super Tuesday, that's when they change it.
Yeah,
They'll
exactly.
set a date, but then if the date for the Super Tuesday is different, and Tennessee always follows the Super Tuesday.
Okay, do you want to leave it as it is now? And what we're doing is following state law. I don't, correct me if you think I'm wrong on this, but I don't think that presidential preference primary
Okay.
date is there.
I will tell you, this provision was drafted off of, based off of Shelby counties and Knox counties. Now, something may have changed in between the time that Knox County passed their charter in 1988. I don't know, but that's
Take
what
a look
that's-
at that for us.
Sure, I'll check that, but that's
And
what that's based on.
I've got one other note on that. The county commission won't set that date. That'll be the election commission. And as far as I know, they follow state law on that. So anyway, any reference to county commission setting those dates, move that to the election commission, and I believe that's set by statute. Qualifying petitions, that remains the same. Okay, that's all set by, it says, where so authorized by law, the board by ordinance. I think we want to keep it, all the election stuff, and it's worked out well as an independent agency, separate and apart of county commission controlling the elections. Is anybody opposed to that? That's what it's been for years. If you don't realize this, the local election commission is a state entity. The election administrator and those employees there are the county employees, but the election commission is formed by state law. It's a state entity. We've dealt with this on a couple of lawsuits before on who's going to pay, but the county always picks up the tab. But anyway, I want you to, let's see, Gavin, what is the question I have here? Okay, just make sure that anytime you reference that board, I think you're trying to say county commission.
Correct.
I think we're going to allow the election commission. Is that all right? They'll stay the same as it is now. The election commission sets those dates. Okay, 704 is something I think is a hot topic now. Nationally, all voters shall have the right to cast a write-in ballot. Okay, as provided by general law, the election commission shall give public notice of the deadlines. Okay, that is the way it is now. Okay, here we've got recall of elected county officials. We talked about this early. 7.05, this is the same type provision, the same offices that we had. I think it's mirroring Knox County. We're missing the highway superintendent. We're missing the court clerk. Knox County doesn't have those positions, and the law director is appointed in Anderson County, not elected. Sure. So do you want recall of, the question is, do you want recall of elected county officials? As we've seen before, basically the county is in a position of having to force an ouster suit to get rid of an elected official. But this would be a recall option. This is different. Okay, I'll say that right now. We've always had the thought that we're going to keep things the same, but what this does is allow a certain, we get enough petitioners, and I think we need to stay with that 15% of the last gubernatorial election, the minimum. You got a blank there. Then an elected official, put that 15% in there, and they can be recalled by the voters. Do you want that procedure or not? As it stands now, it's an ouster provision. That's a very high hurdle. Recall is done by the citizens. It's up to you.
I want to keep it the same.
Okay.
It's just me.
Everybody all right on keeping it the same?
Well, I think one of the major purposes of doing a charter form of government is to give power back to the people.
Okay.
And by keeping this here, it lets the people decide instead of doing an outsourcing.
Very good point.
So it gives the power back, and that's the whole purpose behind the charter.
Okay.
I just don't want us to get into a situation where it was in the past of the ouster suit, where we're sitting here paying out thousands of dollars for attorney fees and things like that, so. That's my thought process.
That's a very
on
good
that.
point too.
But an ouster, if we leave it like it is, it takes an ouster suit.
Right. That's a high hurdle, high threshold.
Yeah, it takes a lot to do that.
Do we want to do the recall? So
That's your other option.
Do I hear
I'm in favor of the recall.
you making a motion on putting that in there?
It's here right now, we just gotta put in the numbers. Yeah, I'm in favor
Well,
of leaving it.
But it's a change,
Yeah.
is what I'm saying.
Need to be careful.
You want to think about this one? It's a big step.
Use your eraser.
I'll second it if he makes a motion.
Yeah, I'll make that a motion, that we include the recall provision in there, but it needs to have high enough numbers that it's not easy to do, so it would have to be something that was serious. But right, I don't like the fact now that in Tennessee in general, if a person's in elected office, without it going through an ouster suit and everything else, man, they can't be removed, period. And I just think that people need to.
You're talking about an elected official. Employees, of course, are at will.
Yeah.
The other thing is,
66%?
Can we set the
Well,
percentage?
the state is changing it for school board members right now to greater than 50%.
And we can say what
You-
election,
you-
Of the people that vote.
yes,
Or-
ma'am.
so we can say of the governor's election.
You can use that as your petition threshold. Now, your petition threshold is different than what it takes to actually recall an elected official. That's much higher. So I think what we're talking about is the 15% on the petition, and then the way it stands is 66% on recall. Now, you can change that. Gavin has left it blank, but that's where we're at.
I think 66% is too high, actually. I like the greater than 50% of the votes cast. And that's what, there's a bill right now to change the school board to that. And I think it's gonna pass.
Greater than 50% of votes
Of
cast.
the votes cast.
But my question is, what about the petition for the recall? I think that 15% is very limited.
It is sometimes.
It's a lot.
If you have a non-contested governor's race, it drops dramatically. If you have like we had last time, a very contested governor's race, then it rises. This charter petition was a non-contested governor's race, and it only took 1,700 and so folks to get this started. that signed a petition. So that's a very important decision. What's your threshold for the petition to start this process? And then the other decision is, what does it take to recall somebody? What percentage?
We need numbers in there.
Do you want to think about this issue? I mean, we don't have to make a decision tonight. This is a big issue.
15% is a reasonable threshold. It is really varied, like I said, according to the governor's race, how contested it was. But I think in a recall election, if more than 50% of the voters vote for removal, then that needs to be the way it goes.
Okay.
It's not easy to do. It's not something, because it's hard to, getting people to vote for something like that is difficult.
Mm-hmm.
Okay.
Very difficult.
And you have to have a special election because
Yeah.
after that, you, what, 90 days?
And it's presently 66%.
No, that's, in another case, it's 66. We've seen that number. I think is it
Yeah.
Shelby County that's got
The
that?
current law for school board members, the recall is 66% of the votes cast.
Well, I
But
just don't
there's a
want
bill
one
right now
vote,
to change
uh,
that to 50.
I mean, I just don't want one vote to kick somebody out if it's that close. I mean, say, because one vote for more than 50%, I mean,
I have another question.
Okay, yes, sir.
We're talking about school board and county commissioners. Are we talking about the voters in that district or countywide?
No, it'd be the voters in the district on a district type appointment, a county commissioner, school board, but on countywide positions, it would be countywide. It's what you look at the electorate for that particular office is. Okay, unless there's no motion, we'll circle back to this at another time. Please keep this on your notes and,
We had a
Did I not get a second? Is
You
that
did.
wrong?
oh, you did?
I did.
Okay, I'm sorry. I'm very sorry.
Yeah, so keeping the 15% and 50%,
Okay.
greater than 50%.
Greater than
votes.
50. Okay, that's the motion.
Yeah.
Okay.
any questions, comments?
Can we word that a little bit better, that it will specify the county commission and school board, so we don't, so people are not out here thinking that it's countywide, it has to be within that district unless it's
For
a
those that are
countywide
elected,
office.
yes, ma'am, you're correct. Gavin, can you add a little clarity to that?
Yes, sir.
What you need, the percentages of the petition, you need the percentages of what it takes to recall. And if you want to address that motion first,
Well, a little clarity here. We're talking about all elected officials,
yes.
all elected local.
Now, I don't think that's going to affect the state offices we have that a lot of people believe are county offices, like the DA, the chancellor, the magistrate, and the circuit court judge. The general sessions judge and judges and juvenile judges are county positions. So I don't think we can control that.
Well, in the one that we had here, it left off the circuit court clerk. And I asked-
Yeah, well, he's adding that. We had another one that was like that before.
Oh, okay.
We've got highway superintendent and the circuit court clerk. We've added those. Let's see. The mayor, sheriff, county clerk, trustee, register of deeds, property assessor, missing the circuit court clerk and the highway superintendent. That's it.
Okay. Any other comments, questions? Okay, so the vote would be to entertain a recall with what the state calls for. on-
15 and, he's calling for 15 and 50. Steve, is that correct?
That's correct.
Or above 50?
Above 50. A majority, simple majority.
Simple majority.
Okay. Well, that's, please, roll call vote.
Commissioner Fritz,
no,
Chairman Stonesifer,
No. Commissioner Motion.
Commissioner Bochamp, Chairman Stonesifer, Commissioner Bochamp,
No.
Chairman Stonesifer, Commissioner Fritz,
No.
Commissioner Bochamp,
Yes.
Commissioner White,
No?
Commissioner Meade,
Yes.
Commissioner Bochamp,
Yes.
3-3?
3-3.
Okay, I think that's an area that
Fails.
some of y'all might want to come back and revisit, so let's just think about that. Okay. All right, I'm going to move on.
If we defeat it, I mean, if we voted it down, why would we come back?
If somebody makes a motion.
Because it could be the difference between passing any charter at all, in which case I don't want to go to jail.
Well, we're going to get a charter out there. I don't want to talk about that. The charter is going to be done. I put my name on an order that went to the chancellor, so I'll be the first one to be in trouble.
Right.
So we're going to do a charter.
I'll make this one comment.
Mhm.
I'd be glad to support recall, but I don't think any recall ought to have that limited, that small a number.
The 15 and the 50.
Yes.
Okay.
I would agree with that.
All right, well, let's come back to this. That's a totally different motion. But let's think about this, and we'll look at it another time. I've got a note here to come back to this.
The reason being, as soon as that's filed, you've got a few days, and you're gonna have to have an election. It's not at the next,
That's
it's
right.
90 days.
That's very, very important here.
It costs a lot of money.
It'll cost a lot of
to have
money.
elections,
And
and that's
you
what-
got to, the one thing about the ouster suit is you got to prove for cause, okay? You've got to lay down reasoning for it. Willful misconduct. Here, you could have a political party, an opposing political party,
And I don't
file.
like this person or something, you know.
File a
and I don't want
petition,
that.
and all it takes, and we've probably got one political party in this county that's over 50% right now. So that I understand your concern about maybe the weak thresholds, but let's think about that and come back. That's something I want you to, in the next few weeks.
That's like if you voted in a tax increase and you made, if you had a small district, it wouldn't take that many people to have an ouster seat.
That's right.
So if,
Or a recall.
Recall.
Yes, that's a very good point.
Jay, if we don't bring this back up, will it stand as it is with the current things that we're doing with the ouster suit?
Yes.
Yes,
Okay,
that's the way it'll be.
okay.
We'll fall back to that ouster suit. And again, that's a judicial proceeding where evidence has to be submitted. A recall, you don't need that. But anyway, we'll move on. Let's see, still going through all that recall stuff on the next page. You might want to read through that if we come back to it. I'm going to move on to Article 8, General Provisions. The first one is the title and filing. These are housekeeping measures that are required under the charter statutes for us to incorporate these areas. Gavin, I have one issue here with the word home rule.
Okay.
One of those AG opinions you sent to me says there's no such thing as home rule in
Yeah,
counties.
Yeah.
There's home rule in municipalities, and we've always called it a charter out here, and that's consistent with the state statutes. So, but if you want to leave, there's, I don't know, 2 or 3 references to home rule. If you want to leave those in there, that's a little bit confusing to the people. We'll just replace home rule with charter.
Yeah, I think that home rule means it's a municipality.
That's the way the statutes are set,
Okay?
sir.
And that's the way the state statutes read, and so I think we need to be consistent with the state statutes.
Yeah, it's been reinforced by an Attorney General's opinion that says there's no such thing as home rule for counties. So, anyway, that's not controlling on the issue, it's just an AG's opinion, but if there's no opposition to that, we'll change everything that says home rule to county charter or charter. Thank you. The definitions here, I need to work with Gavin. I think there's several other things we need to find here. He's done a good job, but what I want to make sure that we clearly define what an ordinance is and what a resolution is, because this is going to be much different. And do you want to have the mayor likes proclamations that she does. Do you want him to write a provision where the mayor has the authority to do proclamations? It's silent right now, so we can have him put proclamations there. Those are, I think the way she writes them is their courtesy things where she honors people on her own. She'll write a proclamation, and like I said before, county commission always talks by resolutions. But anyway, that's one. If anybody here has a term or a phrase you feel like is not clearly defined, let me know, and we're going to get it defined. Gavin will put together a good definition. I think that's important because where there's gray areas within the charter and you try to interpret it, whether it be a citizen or an attorney or anyone, the first thing we do is go back to the definitions. What does this actually mean? I decided a zoning case, we wrote an opinion this week that the actual definitions controlled. So that's very important to have clear definitions of some of the operative terms in the charter. Yes, sir.
Yeah, things might have changed since 2004, 2005.
Not much.
But, we had, the mayor wasn't the only one that could do proclamations. We had people in the community that, say somebody from Jerry's district came to him and wanted a proclamation honoring somebody, that he could present it. It didn't necessarily have to be.
Oh, you get me wrong.
Courtesy resolution.
What county commission on, if Jerry had somebody in his district that's an outstanding citizen, he wants to honor them here, we would do a resolution honoring those individuals. We're not saying that you can't honor individuals, and we're not saying that anybody on the county commission can't say, Jay, write a resolution honoring so-and-so, he's done this for the community. No, we're going to allow that. I don't see any reason not to. But the issue is the mayor does it a little bit different. She'll write a proclamation, not a resolution, and submit it to county commission. I don't have a problem with that. But the proclamation is doing the exact same thing as the resolution. And the reason the county commission does a resolution is there's state law and AG's opinion that say that the county commission speaks for the county through resolutions. So that's why we've always done a resolution. Okay? All right, but anyway, I'm really concerned about this, these definitions, and some of our deep thinkers here, please be thinking about any other term. And Gavin, I've got several that I want you to look at. Thank you.
But the proclamation would be mayor only.
I don't have a problem with any county commissioner if they wanted to write something up and say, I wrote this proclamation, but if you ask me to do it, I'm going to write a resolution honoring people. That's the way we've done it through my office.
We don't have to specify who.
Not really, unless we want to define proclamation, and
We got 4 commissioners here.
I think our mayor right now likes proclamations.
And these commissioners might too. if they-
Yeah, I think so, and the thing about what we're doing now is you have to think about the future. The mayor's not always gonna be the mayor, who it is now, and the people sitting here is not always gonna be a commissioner.
Well, I know it, but,
We're setting precedent for the future.
right, but we don't want to, in the definition of proclamation, we don't want it just to be for the mayor.
No, you don't have to, but I don't, the one thing I don't want to do is put ourselves in a corner and limit our options. I want to have the flexibility in here, and if we start saying, okay, only the mayor can do proclamations, then we're getting a little bit, putting ourselves in a corner, but I think we should honor a proclamation, a resolution, or however it comes forward to honor somebody. It's very important to honor citizens that they've done a fabulous job in our
Okay.
community.
I mean-
But I think either way is fine with me, and I think it's certainly legal.
I misunderstood you, because I thought when you said proclamation, that, just for the mayor or something.
No, the mayor is the one now. Mayor Frank writes proclamations, and I've never had a problem with it. But anyway, we may want to give her at least the authority to write, the mayor to write a proclamation, okay? We'll be talking about that. All right, I'm going to change the page. Talks about that 2/3 vote. We do have 2/3 that in a couple of different places, but again, we've got one area that's a 3/4 vote, and that is a super majority when a budget issue comes before commission and it's never been before the budget committee. A lot of people misinterpret that, think it's 2/3, it's actually 3/4. I don't want to put that in here because we've adopted that as a policy. And I want to have the latitude for the Finance Committee to adopt policies under the 81 Act or whatever financial act we're under.
Well, that's under our commission rules, too.
And it's in the rules, so I don't think we need to put that 3/4 in here because we do have the ability to adopt rules. Make sure you have under the county legislative body, I think there's a state law, but make sure we're clear, Gavin, that the county commission can set their own rules. They basically operate under the latest version of Robert's Rules. When it's silent, they do have some pretty explicit rules on procedural issues that are not contained in Robert's Rules. I can get those to you, but I just want to make sure they have the authority to set their own rules as an entity for the organization and conduction of business before the county commission. All right, I'm down to, now, BL, I think when we first brought up this idea of charter review, you wanted to go parallel with the state statute on that for the governor on the Constitution. They've got every 8 years, and that parallels Shelby and Knox, doesn't it, Gavin? 8? Okay, is everybody okay? There'll be a charter review. You see, Oak Ridge does a good job. Every 8 years, they come back and go through the charter and see if there's any amendments. What we're saying here in subsection D of 8.05 is we'll do it under every 8 years. They'll come back and review that charter.
But, yeah, I don't think I specified review.
Amendments.
It was when it could be amended.
Mm-hmm.
And how many times.
Okay. There is some debate, and we saw that in a couple of AG opinions that myself and Gavin saw, that what's your thoughts on the Charter Commission passing, with the assistance of the legislative body, passing ordinances that change the charter? I've always felt like if you were going to amend the charter, it had to go through the Charter Commission, had to come to County Commission, then you put it to the voters on a referendum on amending the charter. But there seems to be some authority that if it's not specified in the charter, it's not contrary to state law, contrary to the charter, you may be able to pass an ordinance to fill in the blanks. Gavin, you want to add to that?
I would have to research it more. I think there is a question, if it's silent in state law, if it's not contrary and the charter's silent. I think it may be possible, but
Filling in the blanks like we have with private acts for years. If it's not contrary to state law, we'll ask for a general law of local application or a private act. So I want to take a look at that to see if areas that are not covered by the charter or not covered by state general law can be enacted by ordinance by the legislative body.
I always thought that if you want to bypass the legislature,
You got a referendum.
you gotta have a referendum.
Yes, sir. It's one of the two. It's one of the two. You can actually combine them both. But one of the two's got to occur for it to be constitutional. All right, I'm down to 8.06. I had a couple county commissioners ask me about prevention of CRT in the school system and in the county as a whole. Here's your discrimination prohibited. This is along the lines of what we have now in our personnel policy. If anybody wanted to broaden this to prohibit CRT, critical race theory, or anything else, it could be amended and stuck in there. I'd have to show you some wording, but if that's, I just want to make sure we have a discrimination prohibition policy. We're required to have that under federal law. We've got it right now. We're totally compliant. But for those individuals that have approached me in the past thinking that We need to have something on the books to prevent critical race theory, disparaging remarks against any race. Then this is where we would put it. Okay, I'll leave that for you guys to think about. That's another national issue. It's strange that we have to deal with national issues at the local level, but it's there, and just think about what you want to see there, if you do want to see
The
it.
local level is what should make the national issue.
That's a good point. We just don't address the same topics. Let's see. This is a little bit different on the next page, 8.07. The mayor shall designate an administrative official to enforce ordinances, resolutions adopted by the county commission pursuant to section 8.06. The mayor does appoint people to enforce our planning and zoning and property maintenance issues and stuff like that in the zoning department, so it's not that far-fetched. But what I like it because of the idea Commissioner Fritz brought forward several times, and if we passed an ordinance on property maintenance cases, then instead of my office having to take them in a full-fledged lawsuit to Chancery Court, the zoning official, the building official can write a ticket on if we pass an ordinance to this effect, and the mayor could appoint the codes enforcement officer or the building commissioner to enforce those ordinances, and they would simply go out like a law enforcement officer and write a citation on a non-custodial arrest. Those would be returnable to General Sessions Court. The way it works now is if there's a zoning violation, it's referred to my office. I try to work it out with the citizen, give them a plan of action with a certain time frame. If they don't comply, we have to file a lawsuit in Chancery Court. So that's a full-fledged lawsuit. It's got discovery and all the other hurdles that are involved in a jury trial or in a trial in Chancery Court. But I do like the idea. I've always supported the idea of Commissioner Fritz it might have been 12 years, Chuck, of allowing these people, our codes enforcement officer or building commissioner, to go out and write citations.
And plus that money stays in the county.
Well, that's in ordinances altogether. That's even if we pass ordinances for our law enforcement officers. But I think it's much more streamlined. It's a quicker process. And if you've ever been in Judge Layton's court, it won't take long to dispose of these. It'll be rather quick. Where I may be dealing with a year or two on a case, Judge Layton would take care of it in a matter of about 5 minutes. So anyway, that's I do like the mayor having that ability to appoint somebody. The only other change there is that you would have your legislative body appoint somebody. But remember, the two people that are more likely to write these ordinances in this regard is in planning and zoning, codes enforcement. Those are under the control of the mayor. So I think she has that opportunity. If we do pass ordinances geared towards law enforcement, and we've talked about this several times, you can adopt the traffic code and keep that money here in Anderson County. Okay, it's the same offenses, and they're just county ordinances. The sheriff's office would enforce those, so the sheriff would have those duties to enforce anything that's along motor vehicle law or anything we put down as a ordinance violation that's subject to return to General Sessions. So I like that idea a lot, and the main reason I like that idea is I like to keep the revenues here in Anderson County instead of sending them down to Nashville where we'll never see them again. We need some type of revenue stream to prop up public safety, not only the sheriff's office, but the detention facility, but also EMS. We need money to prop those up, and I really think that the revenues generated off ordinances could really help. So that's something to consider. Any comments on that?
Well,
I was just talking about the mayor.
Let me actually go back. There's a spot that we jumped over real quick.
Okay.
Get it a chance. Back in 805 C, it talks about that the voters of the county may frame proposed amendments to charter by petition addressed to the board.
Mm-hmm.
Where it says board, does that mean the county commission?
That if you recall, about a year and a half ago, this body passed a section on amendments to the charter that's different than this.
Yes.
It would come, if the citizens wanted a change, they send it to the Charter Commission. The Charter Commission reviews it in depth, that's where they have the time, and then sends it up to the County Commission. County Commission looks at it and determines whether or not that it is a viable option, and then they send it to the Election Commission for a referendum for ratification of that decision. So we put another step into it when we looked at this before.
Okay, so
Two-thirds vote.
where are we gonna address basically the continuation of the Charter Commission? And we need to clarify that when it says the board, it's talking about the charter.
Yes, we've already done that. We made that early on today. We asked, I understand, it's all through here, okay? But Gavin's gonna straighten it out.
I just wasn't clear to me.
Okay, he's gonna straighten that out. We talked about it. I don't want any confusion between the Board of Commissioners, the Board of Education, any other board we have here. He's gonna put down for the Board of Commissioners, it'll be the legislative body, and they'll take some of that out. But
Well, just to hear where it says board, it actually means Charter Commission.
no, I think he's talking about legislative body here.
In this spot, yes, sir.
Yes.
Legislative body.
I'm going to insert the provision that you addressed a year and a half ago in here that is a little bit different than this. It requires another step in there,
Yeah.
which I think we all thought that that's better because the Charter Commission would have a chance to review it in depth, in detail, and then make it a recommendation to County Commission. County Commission then would pass it. As you see, it's effective, but that's effective on asking the Election Commission to call for a referendum. So you see that's the wording is a little bit different there. But it says it's effective. You think the actual ordinance is effective at that time, or the amendment is effective.
So is there some place that we're coming to that's gonna address the continuation of the Charter Commission?
Yes,
And then they're replaced?
you've already
Yeah, okay.
made that decision.
Okay.
Yes, sir.
Okay, great.
Okay, all right, I'm back down. On this conflict of interest, I like the way you have it here, Gavin. I just want it to mirror state law.
Okay.
And that has changed a couple years ago. And it looks like there's a bill that Commissioner Meade has shared with me, I think you did, or somebody did, that they're looking at the conflict of interest provision again this year. This is the issue that pops up all the time, is if you are a county employee and you also sit on the legislative body, when do you need to abstain? The current law says that you can vote on amendments, you can vote on the departmental budget, on the overall budget, but you cannot vote on that departmental budget. That's a conflict of interest. And that's worked well for the past couple of years, but let's see how this shakes out during this session. This is probably the 5th time in 20 years the General Assembly's looked at this conflict of interest provision. I thought it was working well, but evidently there's a problem for somebody. But it's very similar to the way Gavin has it written. And Gavin has also put in the old section where you can make that statement that we used to hear all the time. And he's got that in here because I am an employee of a governmental entity unit. I have a conflict of interest in the proposal about to be voted on. However, I declare that my argument and my vote answer only to my conscience and my obligation to my constituents and to the citizens this body represents. Well, the General Assembly evidently didn't like that in all matters, and they wanted to put some restrictions on it, and that's why that if you are a county employee and you sit on the legislative body, you cannot vote on that departmental budget. Okay, so that's the way it stands right now. So we will take a look at that and see what happens this session. Gavin, that section E has a chairman woman on
Sure.
it, so just put chair there. Here's F is something I thought was interesting. No elected or appointed official or employee of Anderson County shall advocate, recommend, supervise, manage, or cause the employment, appointment, promotion, transfer, or advancement of his or her relative to an office or position of employment within Anderson County government. That means that if you're an elected or appointed official, you can't go down to HR and say, hire my wife, hire my daughter, hire my son, or recommend them. It says recommend. So, believe it or not, we get a lot of employees in county government that are related to people here, and they've served very well. A lot of them have done a fantastic job. But that's something I want you to seriously consider about, because that is more strict than our policy. Now, we have a nepotism policy in Anderson County. That's embodied in your personnel handbook. You can't supervise anybody that's related to you in the first degree, so that's taken care of. But what we're saying here is a little bit broader. Advocate and recommend or cause the employment, those are broad terms. And the way I see that is if you walk down to HR, you saw an opening and said, hey, I got a family member, I think they'd be interested in this job, and you recommend them to HR for hiring, then you're violating this section as it's written.
You know,
I-
Jay,
I think it's important to note that it's not saying that a relative couldn't be employed by
No, it's not saying that. You can't go to, the elected or the appointed official can't go down there and recommend and say, hey, I need you to hire my daughter, I need you to hire my wife or something. No, that's going to be off limits. I don't know that that's happened, but I do know we have a lot of relatives here.
when, we had the outside audit of the school system,
Yes, sir.
they recommended a nepotism policy.
Mhm.
The board adopted one. Here's one, and I pulled this one.
Mhm.
I'll give this to you. This is what the Anderson County Board of Education has, and you might wanna look at, I like what was written here.
Yeah, this is really similar to the county policy. It's in our personnel.
Yep.
Yeah, this is very similar to the county policy.
It won't keep that one won't keep a person from being hired. It just says that they cannot be supervised by a relative.
They couldn't be
Absolutely.
hired to work for you if they're your, if you're their relative.
Well, no, I couldn't, as director of schools, I couldn't because the director of schools does the hiring. But we'll say, you might have a principal in the school system, and they have a child that applies to be a teacher. Well, they could be hired by the school by the director of schools to teach at other schools, but not where he's principal.
Yeah.
And under this, they couldn't recommend that person.
Right.
Because that it says advocate, recommend, then you got your supervision and management.
Yeah.
But this is broader. This is broader. This means they could certainly be hired by county government or the school system, but it's not like anybody can go down there and recommend them or advocate that's a family member, elected or appointed official.
Well, if you had something similar to that, an elected official couldn't hire a relative to work in their office.
That's right. The county policy, if you supervise inline, if you're an inline supervisor, you cannot, that nepotism policy will kick in. Now, people might say, well, I know of a couple of situations that we have 2 or 3 grandfather provisions in the county that were hired 20 and 30 years ago. But there's very few. The nepotism policy is in the personnel policy. It is followed very closely. Okay. G is another section on that. It really fits a little bit better on the conflict side. An elected official or employee of Anderson County with responsibility to vote on a measure shall disclose during the meeting at which the vote takes place before any discussions or vote on the measure, and so it appears in the minutes, any personal interest that affects or that would lead a reasonable person to infer that affects the official's vote on the measure. That is almost identical to the old state statute right there. The General Assembly thought that may not be strong enough and went back and basically said yay or nay, whether you can vote or not. But remember, you could declare your conflict of interest. You may have an interest in a company that's doing business with the county. That's where we found it before. But anyway, what this means is if anybody has an interest in that would need to be disclosed, they have to do it before the vote. Okay? If you're voting on a contract, you may have a portion of that company, you have to disclose that. The way it is now, we don't allow it. We've made interpretations on that no way are we going to allow officials to be in business, and that's in the 81 Act. We had an issue that popped up last year, and we were under the 81 Act. The 81 Act is very stringent on this issue and rigid, and if you are an employee of Anderson County, you can't do business with Anderson County. That's the way it's been under the 81 Act. So this may be gives a little bit more lenience, but that is the old statute where somebody could get up here and declare, hey, I own half that company, or that's my company, and everybody else say, oh, it's all right, and vote for it. Well, that would allow it if they disclose that before the vote. The way it stands now under the 81 Act, you can't do business with the county.
What, do we need to put this in?
That's your decision. If you want it to be as it stands right now, it's much more strict than this.
I
think we went that direction on purpose.
I thought that's what we said, what we had.
That is what we had,
what I'm talking
not exactly this.
No.
Now, it's changed.
Yeah.
When we went to the 81, we went to a statute that is much more strict. We've had to call the comptroller last year and get an opinion from them on something that was fairly minor that they said was against the law.
Well, we need to substitute then, though.
Well, you've already got it substituted. You always want to give the Finance Committee the ability to set policies and through the way they do business in the finance and purchasing area, and the HR Committee sets policies for personnel policies, which comes back to County Commission that have to be voted on by County Commission. So the way 81 Act, one of the good things about it is the Finance Committee can set these policies, and they have just made the decision to follow the 81 Act. And that's where I don't think we have a choice as long as we're under the 81 Act, because you go back to that same adage that you can't be in conflict with state law. And the conflict of interest provision in the 81 Act, which we're under right now, is more stringent than this.
We need to take G out then.
Yes.
This needs to reflect the way we've actually.
Let's, can you look at the 81 Act conflict provision? We've talked about this with the County Attorneys Association. They've asked for an amendment on it, and we'll see where we're at. We had an employee, and it was a very minor issue, but when you read the language of the 81 Act, it basically prohibits any business of any employee with the county.
If I may ask a question, do
Yes,
you
sir.
want the provision in the 81 Act in here to substitute G, or do you want that to be a policy that's up to the?
I think it needs to be a policy.
Okay.
Because we may have a situation where the legislative body wants to move out from under the 81 Act and move to another. There's 3 alternate forms of budgeting in Tennessee. You can also go under the general law in Title 12, or you can have private acts. I think Campbell County's got a private act on that. So there's some options there, but right now the county legislative body has decided to go under the 81 Act. That could change. The 57 Act is pretty restrictive that we used to have on these type things. But anyway, let's look at that. Let's look at the wording and see if we can massage that to get it to fit in G. If not, we'll just say it's a policy. It's actually a state law. That's what it is. That's been adopted as a policy in Anderson County. It's pretty clear. Okay. I'm down to, okay, it's at the top there of 8.09, top of the page. The mayor and such other county officers, employees, as the board may provide, shall give bond in the amount of the surety form prescribed by the board. The General Assembly changed that law 2 years ago to allow for to do a comprehensive blanket bond, and we've gone to that route instead of going out and putting individual bonds on people. It's very similar to what we did for our employees, other than the elected officials. It just has to be in the amount of some of the offices have higher bonds than others if you handle a lot of money. But the last election, we, instead of filing individual bonds, we went with the new state law and filed a blanket bond in the amount, the cumulative amount for what was required by the statute. So let's look at that. That's changed here not long ago. Residence and qualifications of county officials. The county official who shall voluntarily remove his or her residence outside the district is immediately forfeits. That's state law. If you move out of your district, if you're elected from a district, that's immediate by operational law. Okay, here's one for lawyers. Any lawyer, either elected or employed by the county in a legal or judiciary capacity, so it applies to judges. I thought the judges were off limits on charters.
Yeah, I think so. We may have to word that a little differently.
I agree with it, but I think they're off limits. But who is suspended or barred from the practice of law in the state of Tennessee shall forfeit that office immediately and shall not hold office or be reemployed during the term. Okay, this is what my question is on that. That sounds like that's all good. The Board of Professional Responsibility will issue a suspension if you don't get your CLE, your continuing legal education. And that suspension might last 2 weeks. Okay, if you happen to be an hour short or something, they'll send you a suspension, say you've got to make up this hour. By the wording of this, you lose your job on that. Now, I've never been in that position. I hope to never be in there. I always keep a bank of CLE, but I can see where that's pretty rigid there. If you, and when you get suspended or disbarred, you have to notify all your clients. That's a requirement, or you will not get your law license. So in the case of me, if I was suspended for any reason, I would have to come to every one of my clients and give notification that, hey, I'm suspended. That's embarrassing. We had a couple of lawyers in this county, not county officials or county lawyers, that have been unfortunate to be suspended, and they've had to mail out letters immediately to every client they've had and tell them, hey, I'm suspended. Don't bring me any business. I can't do anything for you. But that is pretty rigid right there. If you spend one day suspended, you could lose your job. Now it says, shall forfeit that office immediately and shall not hold office or be reemployed during the term of such suspension or disbarment. It doesn't say you get your job back. So
Is that not inferred?
that's, no, it doesn't say that. It says you can't hold office or be reemployed. I guess that's by the county during the term, but it doesn't say you get your job back. So we've got a few lawyers that work for us, not many. I'd hope that nobody's in this situation. The two that I work closest with, we keep a running total of our CLE and try to have a bank of, in fact, I usually roll over enough for the next year. But anyway, I want you to look at that. Ex officio members, boards, authorities, and commissions. Now, Gavin, we use the term ex officio out here, a little bit different than the normal legal definition. The way we use it out here is you're a non-voting member, okay? Actually, ex officio means by virtue of your position. And that may be what this is talking about, because what it says in 8.11, no county officer or employee who is compensated for his or her service by salary shall receive additional salary as an ex officio member of a county board, commission, authority, or agency. Okay, let me tell you of a couple situations that come to mind. We have an employee that has extra duties, taking minutes for the Conservation Board. They're given a stipend. We have, I think, another employee that's does the same thing with another committee. They're given they keep the minutes, keep the records. They're given a small stipend that's not during their work hours. They have to stay after work. The thought was, hey, we hire you in at a salary to work 40 hours in this job duty. Anything else that you work in another position, we compensate you for it. And that was the thought behind that. You also have county commissioners that are employed with the county, and also are county legislative board members. Does this mean that they can't be compensated? Then we have another gentleman that helps down at Blockhouse Valley, and his off time, he works full-time in another department and comes down there, and he's compensated individually. So the wording there, no county officer or employee, is pretty broad. Are you following me on this? That means if they are asked to do something extra that's outside their job duties and off their normal work hours, we can't compensate them for it, and that may be tough.
I don't like the way this reads, and this would, to me, be another change in the way we do business.
Mm-hmm.
I think it's important that if someone is really doing something extra in addition to what their job is.
And it's not during their work hours that we
It's not
already
during their
compensate
work
them for.
hours. There should be where they may be compensated, but they don't necessarily have to be. There's not a requirement to compensate them for other things you ask them to do, but you may.
Yeah, they're all voluntary. They go in and say, hey, I'd like to do that. They look at the applicants and decide. The term ex officio here is what kind of I'm stumbling on. Is it the normal Black's Law dictionary definition of ex officio, or is it the way we do it here in Anderson County, and ex officio means you're a non-voting member of the committee? That's the way we've done it for years. But the true definition is not the way we work it here in Anderson County.
Well, it also helps people who are in low-paying jobs to supplement their income with an additional work.
Absolutely, absolutely. And that's what we have. We don't have any high-level supervisors or elected officials that are doing this. These are all rank-and-file employees that are given extra duties outside the normal work hours that we pay them a salary for, and that's where we find this. So you might want to think about 8.11, and let's circle back to that and see how you want to deal with that. But are you talking about ex officio, the true definition?
I think it is talking about the true
I
definition.
do too. Otherwise,
That's how I understood
that's
it.
very limited.
Right.
Okay, I want to look.
Maybe here's just a case, we have an example right here in the room. And Nat gets paid for her work with the Charter Commission, which is above and beyond.
That's a
her
good
own
example.
job.
Yes.
Yeah, I don't think she makes very much an hour doing it.
Jay,
Yes, sir.
and I don't know if this is happening now or not, but one of the water boards or utility districts used to pay, and you had commissioners that served on that, and they got
That would implicate this issue here too. I don't think we have anybody anymore. Do we have anybody on Anderson County Water Authority? I don't think we do. but we have had in the past. But yes, that would be a good example of it. Okay, 8.12 is private acts between September 1, a certain day. It shall be the duty of the law director and the board to review all public acts having local application, that's those population bracket laws, okay, to Anderson County, and all private acts which affect Anderson County of the General Assembly of the State of Tennessee, not in conflict with the provisions of this charter, for the purpose of board enacting ordinances to replace such acts. That's what the conversation I had with Gavin here a little bit ago is, that there's this thought that when you pass a charter, you are resetting county government, that all private acts that, and I believe Gavin and I need to talk about this, but all private acts that are in conflict with the charter are superseded, okay, unless they're specifically set out. Now, we have a large volume of private acts, okay, and we just dealt with the fireworks one back in 1947. Under that belief, we tried to amend that and didn't, missed it by a few votes to allow fireworks. Well, that would be out the window right off the bat. Some of the big ones, law director position is a private act. Do we need to reset that? Does this fall within the definition of conflict with state law? No, the state law is the private act. Does it need to be adopted by ordinance after the fact? Do we need to look at something else? Or is it not part of the county government structure and is allowable? That's the big debate there. And that's just one example. The private acts that Anderson County has on file is a book about this thick. Now, some of them have been superseded by new private acts. Some of them have been superseded by general law of local application. Some have been superseded by general law itself. Unneeded. I like that. We need to go through and say this is no longer applicable to Anderson County and call those, because it is very confusing when you go back. The school system is one of those. They've got a lot of different private acts on the books, but the one that we really look to that controls is the 02 one. But there's numerous issues that we've done private acts on in the past, and the question is, do we need to come back and pass those again? Or are they in this gray area that they don't need to be passed again? Or do we need to specifically put those private acts in the charter? There's several options there, wouldn't you think?
Yes, so looking to Shelby County, Knox County, it appears to me, and a couple other lawyers in our office, that Shelby County has taken the approach of when it gets to a specific provision, they'll adopt or incorporate by reference their governing private act. And then they also had a provision kind of similar to the to this paragraph right here, incorporating and ratifying all others. Knox County did it a little differently. I think they have this, but it makes it to where if they're not mentioned or if they're in conflict, they automatically fall away. So Knox County gave themselves 1 year after the charter was passed to, I guess, present the private acts they wanted to keep to the commission to pass them by ordinance. And John tells the story that when Richard Beeler was the county law director of Knox County, they hadn't done that. I think it was like 11 months and 15 days had gone by, and they hadn't done that, and they had a rush to get all the private acts together and come before the commission and choose which ones they wanted. So that's how Knox County did it. And if you look, I have it here, but it's online. Knox County has a specific, almost like an exhibit to the charter that references the private acts that were in effect previous to the charter adoption, and then it has the ordinance number that ratified that existing private act. So that's a little different than Shelby County. So there's multiple ways to do it, like Jay said. We may have to talk about whether it's needed or not, but I think we feel at our office that you at least need a provision
To say they're
to say that
adopted in
they're
the charter.
adopted. If you want to readopt all private acts,
We don't want to do that
Okay.
because we've got private acts on the books, as I said, they're in conflict with exactly what we're doing now, that are 100 years old.
right. So it was our thought, and this is totally up to you all, that this provision would allow Jay, as law director, to go through the private acts that you all want to keep, or the commission wants to keep, and present them and have them readopted by ordinance, and do it similar to Knox County, where they have almost like an exhibit that incorporates those into the charter. It's totally up to you, but there are multiple ways to do it now.
I think so too. What I would like to do is,
I thought we could just, if we didn't make the changes here, that everything stayed like it was.
well, that's that 5-1-210 that explicitly says, and I don't have the language here, but it says private acts stand. As if they, on the date of passage, if they're in effect. So we're dealing with some contrary AG opinions to a state statute that's interpreted one way by some folks and others by another way by other lawyers. But there is a provision, 5-1-210, is that close enough?
One.
And it says in there that private acts stand, and we've talked about that in here. But I think this is a good opportunity to go back and look at some of these old private acts that have never been repealed and get them off the books because, again, they've been supplanted. There's something more modern in general law. There might even be a private act like the school system. And we need to take a look. We need to get rid of those because there's absolutely no reason in the world to have those. They just add confusion to any legal analysis on that. But anyway, that's where we're at on private acts, and we'll try to work through that because the last sentence here, so let's see. All other public acts with local application to Anderson County, that's your general laws of local application by population brackets, and all private acts which affect Anderson County of the General Assembly of the State of Tennessee shall become null and void. No further force and effect after September 1, whenever this is adopted. So that's a problem, and that's why we're having this discussion. Okay. Okay, the effective date is something I want to talk to you about. If this goes to referendum in August or November, and it's passed by the citizens at that time, when do you want to make it effective? Okay? There's some thought that we've already got our office holders reelected to a new 4-year term or a new 8-year term. And we probably need to put an effective date of at least 2, maybe 4 years out. That's the thought there. If we make it effective when it's passed, I think we have some problems there that we're not going to be contemplating right now. But that's a thought, and I'm not asking for a decision. But the question is, when do you want, if it is passed by the voters, at what point do you want it effective? The first draft I sent you, nobody had an issue with it, all the elections, and that would all be effective on that 4 years later.
2026,
Okay, so that's where we're at. Do we want it to all be effective at one time, or do we want to start getting into this early? The transition period may be needed. There's no doubt about it. We want to make it, and we've made the commitment to keep it as close as possible, but you see, as we try to keep it as close as possible to what we're doing now, that there's other things that we've talked about that may be slightly different, like the recall we talked about tonight. But anyway, I'm not asking for an answer on that, but when the effective date, the other thing I need an answer on in the next few months is, do you want to present it for the August general election, or do you want to put it on the ballot in November for the midterm federal elections? There is some thought that you may have more participation on that November election, although our county elections are in August. So one way or the other, we need to make a decision on when we're going to do that. What's better for the citizens? Is it too much on the ballot in August for them to make an informed decision on this charter? If so, then we need to wait till November. If you want to get all county matters consolidated, the elections and the charter, then we need to put it in August. But we've always said, this body, that we need an educational period for our citizens to let them know what's in it, if there's a change, what changes we have, why we made it. And it's going to take a few months to do that. And if you look at the state statute, that's really a requirement that we let the citizens know. We can't advocate one position or the other. Hey, you need to pass this. There's a provision that says you can't do that. But educating the voters is smart. As we've always said before, an informed decision is a good decision. I don't want people going to vote on this charter. It means a lot to this county, and saying, I don't know what's in it. I don't know what this means. So that's, the educational period is very important. Again, you don't need to advocate one position or the other, but you need to be able to say, this is what's in here, this is what we changed, this is what we didn't change.
Jay,
Mr.
go ahead.
Well, after you get finished, let me,
We have, in November, we'll have a live turnout.
We will, you think? Because I heard we would have a big turnout.
Well, I don't know who's on there that's going to be any competitive races. We don't have, it's not a presidential
No.
election. We don't have a senator being elected. There'll be token
Right.
token opposition for, our,
State House.
well, the state house and the U.S. House and the governor.
Right.
So I don't see much of a turnout.
Okay. Good point. Okay. Again, I'm not asking for a decision, but be thinking about this. This is critical. All right.
Chuck had his.
Chuck, I'm sorry.
I just had a question. There was many things that we've had going on in District 1 and things like that. We made announcements and stuff here through the county commission meetings. We put it on Channel 95. We do all kinds of other stuff. And then we get criticized saying we didn't know about it, you didn't tell us, or you didn't do this, you didn't do that. This right here is going to be a pretty good sized document. Other than word of mouth and people trying to tell them, which by word of mouth, you can tell somebody what's in there, what you think is, or what you want them to believe is in there.
Mm-hmm.
How is the citizens going to actually truly know what is in this charter commission? So when they go vote, they actually know what they're voting on.
Very good point. What we'll do is we'll make announcements at county commission through all the newspapers and in the county and WISH and things like that, that we've got a link on the charter commission. We have a website off the county website. We've got a link there, and we'll steer everyone to that link. And then we'll have to have it published in the paper. I think that's a good idea. We might not have to have the whole thing published. There's no requirement there, but a summary is certainly something I think would be advantageous. And then direct anybody to that link. Some people still are not computer savvy. People
I
ask
found
for-
that out big time.
Yeah, and we take that for granted because we all use a computer all the time. We're going to have to, if somebody calls one of our charter commissioners and says, I don't understand what it is and I don't know how to access this link you call, then we're going to have to take them a copy of the charter and deliver it to them.
Because I know if you're for the charter or you're against the charter, if you talk to someone, you're gonna lead them your way.
Absolutely.
And you want people to know what is truly, actually is in there, so when they go to vote, they know what,
It's so important.
what they're actually voting on, not what someone wants you to vote on.
Absolutely. And again, we can't, I know that this is kind of silly, but a charter commissioner can't advocate one way or the other.
Right.
They just are supposed to be neutral and objective and steer them, we can give a summary. We can say, this is what's changed, this is not what's changed, and we can steer them to the link. But other than that, it gets to a point where you may be advocating a position if you start going through it. And then I like the idea of having the link, and I like the idea of anybody that wants a copy, we'll get it to you. We'll mail it to you, we'll hand deliver it to you. But the educational phase is critically important. We've known that from the beginning that we started this. We have, I think tonight is the biggest amount of visitors we've had in several meetings. Believe it or not, we've had many meetings that we didn't have a single citizen here.
Well, can you and whoever then do maybe a special thing on Channel 95?
Of
Where it
course.
can be run over and over again, explaining the outline of everything that's being presented? And
Whatever we do, we're not going to neglect the educational component to our citizens.
'Cause I just really
This is
truly
very
want them to
different.
know, every detail, what is changing.
I do too.
What's gonna be different, and they'll actually know the true facts behind this whole thing.
I had a gentleman in my district that's told me numerous times that he's not for charter. He has said, I want it done since it's been done since 1802. It's worked fine here as far as I'm concerned. I talked to him about some things that the Charter Commission was doing, and I told him about the enterprise zones up in Rocky Top, and that we had the ability to adopt enterprise zones. And he said, what's that? And he said, I'm all for that. And I said, we can't do it unless you're a charter form of government. And then there's a lot of people latching on to this recall portion. There's things that, even though we've always had the idea we wouldn't change much, we just tried to get it down on paper and do a good job with what we're doing. You see some things as we go through this process that may make us a little bit better form of government. And that's up for you to decide and the voters. But number one is we need to educate the voters and steer them in the right direction where they can get the material.
John and Gavin and I walked out of here at one meeting, and he was telling me, he said that he's obligated to help us with a pamphlet
He is, it's in his contract.
to make, that would outline changes.
Mhm.
What's different? They have to rely heavily on that. I mean, I'm not one I'm not gonna go out here and say I'm for or against it. That's up to the voters,
It is.
but they need to know what the changes are.
Mhm.
And we said by a vote to be very limited changes.
That's right.
Unless it had,
And that's why
I think that's what.
you may think it's a lot of issues we're bringing to you, but it's really not. We might have talked about 15 things tonight that had some discussion, and you might have seen 2 or 3 that caught your interest. But I don't think the citizens want a big change, but there is some ideas that are out there that may be beneficial to us. Anybody else have a comment on that? Okay.
Just quickly.
Oh, I'm sorry, sir.
Oh,
You want to come up here and talk?
I would love to, yes.
Yes, sir.
We had a discussion, I was afraid he was gonna forget. Yes, sir, my name is Nathan Mullins. I apologize, because, y'all are doing a lot of work here tonight, okay? I'm not trying to keep y'all here and get y'all all tired after you're dealing with these very intellectual discussions. And I honor your participation, because I've been a fan of yours for a while, sir, so I'd always enjoy listening to what you were saying. And I wanted to remark upon one of the ideas that you brought forward, that you shared with Mr. Mead as well. And that is the federal election brings with it a huge amount of publicity. People tend to fall along party lines and tend to compartmentalize the area they have in their mind for current events along what they plan to do about the issue they want during that federal election. It's like you said, if you wait till November to explain for a year the minutia, then people may or may, like you said, may have forgotten what was important along party lines, specifically in relation to the issue that you brought up over and over again, which is obviously very important to the public, which is the school board issue. If the school board issue is connected to the federal issue, it's all rolled into one. In other words, you vote conservative or you vote for progressive, when you vote for the president, when you vote for everybody, then people are more likely to be able to efficiently remember. That's their intention, and not overly rationalize the longer the year rolls out. So I think that's incredibly important, what you said, because of your many years, decades of experience being in here, is that you have foreseen how people tend to fall into certain lines of habit. So I think it's beautiful that you mentioned that. That issue is preeminent, as you said, across this country. And the people have a mandate. What we don't want as the people is to watch the media dilute, rearrange, and obfuscate the issue. So we need a simple, direct target for the people so that they can efficiently remember to vote down the line for that issue that they have said is most important to them, which is CRT specifically. The reason y'all are bringing this to attention, the 50% plus one, which is beautiful, even possibly a lower threshold, is because that CRT issue is going to happen at some point. Like you said, it could happen, unfortunately, with dark money pushing an issue one way or the other. But regardless, it's a huge issue. And I'm suggesting basically that it all be rolled into one big event connected to the federal choice, because people cannot prioritize over a long term without the media or some other politician obfuscating or rationalizing. And so it's got to all be dealt with as a big deal. And the best way to get it a big deal is you're voting red or blue in a federal election. And that dictates what's your decision, because it's going to be straight down the line. Red's going to vote anti-CRT, and blue's going to vote progressive for CRT. Period, end of story. Everybody knows that. So thank you for bringing that to the attention. Thank you for bringing it to so close to a vote, because the people have spoken. And one more thing, if I would throw out, I haven't been to law school like this young gentleman. He's a smart young man, and he could sink me in his chess game in a half a second, okay? But I do take issue with using Shelby County and larger counties in Tennessee as an example of where we should be going, because Shelby County is, in my opinion, not representative of Tennessee, except maybe culturally in some degrees. It is a profligate cesspool of accidental problems that have been allowed to occur by some bad legislators over there. We do things right over here in East Tennessee. So what I'm saying, that's just my 2 cents on that issue. But I commend y'all for having the courage of your convictions to come so close to the issue at hand for the regular voter. And then again, like you said, with your great experience, to know how quickly the people can forget if they don't have an opportunity to vote the big issue when the time is at hand. So again, I yield to your experience, to your expertise, but thank you for the opportunity to reaffirm that this CRT issue isn't going away. It's a ball rolling down the hill, and it's only getting faster. So thank you for allowing. Thank you.
Very well said. Thank you, Mr.
Come back and
Mullins.
see us.
I'll tell you, Mr. Mullins, and the whole issue with Shelby County and Knox is this. They're the only 2 charter counties in the state.
Yeah,
So neither one of them fit what we do here.
right.
And we're trying to massage this thing. We said all along, we don't want to adopt what Shelby County has, and we're not Knox County. And we're trying to get something that's good for our people here. But thank you for your comments. That was very well said.
I'll thank you too. I'll just say that we've, as Jay said, we looked to them because they are the only 2, and we've looked to them as both of what they've done similar, just to give Anderson County, the Anderson County people the options, and what they've done different to see where Anderson County has leeway to do their own thing. So it's not that we're pushing one county or the other. Absolutely not. We're just
I
giving
think
you
that
the
was in our
options.
marching orders to John early on.
Oh,
We don't want to be Knox County. We don't want to be Shelby.
And-
We
and-
want to be Anderson.
Correct.
And,
Yes, sir.
That, unfortunately, the only 2 resources we have are those large counties. Steve, did you have a
I think
comment?
it's also important, maybe some people might be watching and some people in the audience, is that looking back at all the stuff that's happened with those counties, is the fact that they went through a lot of grief before their charters were finally got together. I mean, they spent a lot of time in court and challenged it for years and years. And so it would only make sense to take a look at, all the ways that they fell and try to make sure we don't do this.
We've looked at the lawsuits in Knox County and looked at the challenges there, and we don't want to make the same mistake.
Correct.
The one that happened in Knox County was an oversight, really, along those lines. But anyway, back to this. Any other questions or comments on Mr. Mullins? Thank you, sir.
No, thank you.
County seal and flag, we have a county seal, but this gives us the power, and the mayor has mentioned that she would like to maybe do a new seal. Ours is pretty old, and list some housekeeping things. 8.13 gives us the opportunity and authority to do a seal and a flag. 8.14 is service of process. That mirrors state law. Health service says we can basically have a hospital, a clinic, a nursing home, and other extended care facilities owned and supported and controlled by the county. I don't think we want to do that, but we have that ability. The only clinic we run is our employee health clinic. The county may act through a nonprofit corporation or authority established to accomplish or carry out any of the above outlined duties. We do that. We have ACDC, Anderson County Economic Development Board. Those are all not-for-profits that go out and do recruiting of businesses for us. And if you notice, we'll deed them land, county land, for them to sell and not have to deal with the laws that we're more restricted of. We have to come in here and you've seen us when we start to sell land, we put a minimum bid on it or something. Everybody knows what we're going to take for it. I mean, we're complying with the law, but it's not very advantageous to get the most amount out of our money, out of our property. So we let Anderson County Economic Development Association do that. The Senior Center has a nonprofit too. So we do have some nonprofits. My recommendation is to leave B in here because we do that. But I don't see us ever in the future operating or managing a hospital or nursing home or extended care facility. Anyway, that's my thoughts on those. Pension benefits retained, that allows us to keep our people in TCRS. Yes, sir.
Back up there. Let's do a what if.
Okay.
If we leave that in there,
They have the authority in the future to do that.
Isn't that another change?
why do we need it in there?
Well, I'm saying we don't need it. That's the reason I made that comment. The only clinic we operate is a employee health clinic. That's totally different. It's not a public clinic. And we have a hospital authority, although it's very rarely utilized, but anytime a hospital is expanded in Anderson County, it has to pass through them. That's rare, but we've seen that happen a couple of times in the past 10 years. So I don't think we'll need subsection A. I could be wrong. It's your decision. I don't see us going that route in the future. If we ever decided to 100 years from now, then you can go back and amend the charter. But right now, I don't see us moving in that direction, but it is allowable under the law. And that's why Gavin's got it in here. Okay, pension benefits, that means that all our TCRS stays the same. You may want to follow a bill that's going through the General Assembly, and we can get you a copy of it right now, that says, and this would apply directly to county commission, that members that don't, if you're offered the health insurance for the county and you take that, that's fine. You're allowed to do that. But if you don't take it, the county has to give you money to equal that compensation of that premium that you pay twice a month for the health insurance. You've heard a lot of people say here before that the people that take the health insurance get, as a county commissioner, get more benefits than the others. Well, that's debatable, but the point is now, if this law passes, you can still take the county health insurance, but that normal premium the county pays for you, the ones that need the health insurance, and I want to make sure we continue to have that because that's a great benefit of the job. But if you don't take it, you'll be compensated with money if you have private health care. That is a bill before the General Assembly right now. It's dropped. It's working through committee. We may see that. We've already addressed this at the Board of Trustees meeting, not this particular bill. But as you know, if we have an employee retire with 30 years of service to Anderson County, they're not Medicare eligible. We give them a small stipend until they get Medicare eligible, and it cuts off. The triggering is you have to have 30 years, you have to reach full retirement, and you have to be under the age of 65. But you do get a small stipend to go out and buy private health care insurance. But anyway, back to 8.16, that keeps our TCRS system in place. We'll still be allowed to enroll, keep your enrollment in TCRS, and that's quite important to many of us that have years in TCRS. Public meetings and public records, that's simply a reflection of state law. The records, you might want to add something here. Because there's so many exceptions in the Tennessee Open Records Law, just something to the extent of state law, something like that. But what it says, to the extent required under Tennessee law, all official meetings of boards, commissions, and authorities shall be public. The only exception I know to that is the executive session to the county legislative body. That's embodied in case law. That's not statutory. B, to the extent required under Tennessee law, all county records shall be public documents and shall be open for inspection. We do that quite frequently, but there's about, I don't know, it's hard to say, maybe 100 exceptions. I actually mentioned this at a seminar for county attorneys, and the guy, the State Open Records Council, said he was working on going through every state statute and looking at the exceptions, and he came back a couple months ago and said there's 900 exceptions to the open records law. I had no idea in Tennessee. So I thought all these years but this is the way we operate in Anderson County. If there's a public record, we give it to any citizen that requests it. There's very few exceptions that we don't. Those are ongoing criminal investigations. We always redact DOBs and social securities and stuff like that, but we try to be overly fair to anyone that needs a governmental document, because the government is the people's government. Yes, sir.
Yeah, here, there, in this 817A, I'd like to make a motion that we delete the word official, because you can't have unofficial meetings of those groups. All meetings are official, okay, or you can't have them at all. So all meetings of the boards, commissions, and authorities shall be public. It's, otherwise, it kind of assumes that there's some kind of unofficial meeting that's okay. See what I'm saying?
Yeah, I got you. And we've got a numbering issue there too. Did you see that?
And-
Severability.
And
Yeah,
and
yeah.
then B, I think it needs to say that all county records shall be public documents, except as specifically accepted.
That's what we were talking about earlier.
Under state law.
Under state law. We don't make exceptions, the county doesn't. All the exceptions to the open records law
Yeah,
are
we
state.
don't make exceptions,
No.
but the state makes exceptions, saying that there are certain documents that are not public.
Right.
And we could be sanctioned if we were releasing those documents, we could be sued.
Yes, Gavin picked that up. Okay, severability, this is a typical provision that you've seen in our contracts. It applies here. If any article, section, or provision of this charter shall be held unconstitutional, invalid, or inapplicable to any person or circumstances, then it is intended and declared by the people of Anderson County that all other articles, sections, or provisions of this charter will still stand. So what that means is if one particular section is held invalid or unconstitutional, the rest is still valid. You don't want one particular provision to make the whole entire charter void, okay? That's kind of common. You've got, in Article 9, you've got some transition provisions, nothing big there. I do want to ask you, and I think this is important, on prior resolutions of the county legislative body, I think they need to remain intact. We've passed a lot of resolutions in the past that we operate from all the time, and to go back and go through those is going to take a lot of time. But remember, resolution is only effective until the day it's changed by the county legislative body. It may change the next meeting, or it may change that same meeting under a certain process. So, but we might want to have a provision there that says on the date of passage that all existing county legislative body resolutions will stay in place, because that is hundreds of resolutions.
Well, the other thing about that is even resolutions that have been superseded are part of the record of how we got to where we are.
That's very
That's
important,
what they need.
very important. Okay, let's see. Pending matters like, we've got a bond going out for additional revenue or funding for a source. That's in the process. It's before closing. You pass the charter, that can continue. If we've got a lawsuit that's been served on us, or a lawsuit that we're bringing against an individual, the charter passes, that stays intact. So we've got those pending matters. That's in 9.03. The judicial proceedings here is a better example. All those cases are not affected, okay, by the adoption of the charter. Okay, doesn't affect zoning, and then we know that. Okay, 9.06 is elected and appointed officers continue to hold their positions for definite terms prior to the effective date of this charter and shall continue to hold office without abridgment. Then 905 gives us all our rights that we have as a corporation to make contracts, obligations, titles, fines, penalties, forfeitures, and fees. These are the things we do. We have the right to sue, the right to be sued, and those should not change. Those are all in Tennessee state law. Again, we cannot be in conflict with Tennessee state law, so those rights need to be in here. The bottom of it, it's 9.08, is the referendum that we will have. That's the preamble. We're allowed to have a short summary. We may want to change that as we finish this up. But what goes to the voters is this short summary, and are you for or against? That's all that the ballot will say, and that's by state law. Yes, sir.
Yeah, this uses the term home rule,
I know, we just asked him to change that. Any questions on what we've done tonight? I've probably talked your ear off and getting to the point where I'm getting hoarse, and that's, takes a lot. But we've got some things we still need to think about, talk about that effective date or think about that. Then also, when you want to bring it to the people, any ideas that we have to educate the citizens of Anderson County on what this contains, I'm certainly open to. We've got some bright thinkers in this body, and we'll do our best to educate everybody. The link thing is one issue, but there, and Channel 95 or ACTV, is a great idea, and maybe even have a couple commissioners get on ACTV and say, you know, this is what we've done, not advocating one position or the other, but what's in the charter. But anyway, be thinking about that, and we're getting towards the end of this thing. Just a few more meetings. I'm going to insert all the stuff that you've asked for in prior meetings, like the enterprise zones. They're so important to so many people in blighted areas. We've taken a look at that, and we've already got the feds have designated several census blocks up towards Rocky Top as enterprise zones, so that's going to be really streamlined. That means we can go in there, you can circumvent federal regulations on building, abatement of asbestos. You can put a lot of incentives in there. We'll still have the ability to have our tourism in designated zones. We've done very well, thanks to Stephanie Wells, with you know, Windrock Mountain and Rocky Top and those things. We'll still have that ability. And there's numerous things you have passed independently that will start incorporating those. But, well, we're just a few months away. Any questions that I can help you with before we go adjourn and go home? All right. Thank you for your time tonight. I do appreciate it. Thank you, Gavin, as always. We do.
One question. now.
Yes, sir.
9's the last chapter, right?
Yes, sir, unless, I think most all your other provisions I can incorporate in other articles, but, yes. Yeah, I won't say that definitively because we may have another article, but from what looking back on it, the other things that you wanted in there, the specific provisions can be incorporated in the previous articles.
Now, next question is, March meeting, we have a rough draft.
You'll be close, the March meeting. I can't promise you that, but it'll be, March may be one that, if I can't have it that first week, we may need to have it the second or third Monday, a short meeting. I don't want to promise anything to you right now. We're really backed up in my office right now, and this is an ongoing project that I have to do at night and on the weekends, and but we'll see if we can. I know we're a couple of months away. We've got a couple of changes to make. Gavin will help me with those. We'll get those made. We'll incorporate the other things that you wanted, you've already voted on, and I'll bring you a rough draft, and then I want to pass that rough draft around and go through it thoroughly, line by line, letter by letter. And then we'll start working on our educational component of this thing.
Okay.
Thank you all so much for your time tonight. Do appreciate you.
Any old business? Any new business?
Motion to adjourn.
Got a motion to adjourn. Any opposition? If not, meeting's adjourned.
Thanks, sir.